BP added more than $70 billion to the U.S. economy in 2022 by making investments from coast to coast. Investments like building charging hubs for fleets of electric buses in California and starting up new infrastructure in the Gulf of Mexico. It's and, not or. See what doing both means for energy nationwide at bp.com/investing in America.
Have you heard? You can listen to your gripping investigations ad-free. Good news. With Amazon Music, you have access to the largest catalog of ad-free top podcasts included with your Prime membership. To start listening, download the Amazon Music app or visit amazon.com/truecrime ad-free. That's amazon.com/truecrime ad-free. And catch up on the latest episodes without the ads.
Content warning, this episode contains discussion of the murder of 2 girls as well as a suicide. If you or someone you know is struggling with suicidal thoughts or ideation, please contact the National Hotline at 988.
So we're recording on November 27th, 2023. And that, of course, is a date we've been anticipating for a while because, as we all know, earlier, the former defense team of Richard Allen, with their own attorneys, filed a couple of writs in the Indiana Supreme Court. More importantly, they filed one writ which said, we want Brad Rosie and Andrew Baldwin to come back on the case as Richard Allen's defense attorneys. We want Judge Gull to be removed as the judge in the case. And finally, we want a trial to be granted within 70 days. The significance of the November 27th date is that was the date by which Judge Gull had a deadline to respond to these arguments. And so we have her response today. And in addition to that, the Attorney General's office has also filed a response to what the defense has put out there. So we're going to discuss all of that today. And before we do, right at the top of the episode, I want to stress that both of these filings obviously come essentially from the state's point of view, or the prosecution's point of view, or Judge Gull's point of view, if you will. And so that means the arguments we're going to be discussing today will be from that point of view. And just keep in mind, that's only one part of it all. Earlier, when we covered the original filings, we presented the defense's point of view. And now we're presenting the prosecution's point of view. So just keep that in mind. This is only going to be one side of things.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is the Delphi murders. Richard Allen goes to the Indiana Supreme Court. Attorney General Todd Rokita and Judge Francis Gull respond. So today was, as Kevin mentioned at the top, November 27th, the deadline for Judge Gull's response. Let's be very clear here. So Judge Francis Gull had until today to respond to one of the writs of mandamus. There are 2. They're both different. The first writ of mandamus is all about the record keeping in this case, whether or not Judge Gull was properly keeping records. So we've talked a bit about that in separate episodes. This episode is for the second writ of mandamus. That deals with essentially, 1, kick Judge Gull off the case. 2, bring back the old defense, namely Andrew Baldwin and Bradley Rosie. And 3, do a speedy trial. That's what this writ is about. So in case you're wondering, well, what about the record keeping? That's not what today's about.
That's another writ. Totally separate matter. The first of the briefs that came out today came from Indiana Attorney General Theodore Rokita and his Chief Counsel of Appeals, Angela Sanchez.
So Rokita has come up in this case before. I think a lot of us were surprised when Rokita didn't actually represent Gull in this matter or have someone from his office represent her. That's what we all expected, but they did not. And we've talked with other attorneys behind the scenes about that. And the general feeling is that was likely due to the fact that the Attorney General's office represented the Department of Correction in this case. And there would just be potentially the view that it looks improper, that there's a conflict of interest. So is that the sense you were getting from people we talked to behind the scenes, Kevin?
Yeah, that was definitely the sense I was getting.
Yeah, I think some people portrayed it as like, Rokita's writing Gull off. He thinks she's wrong, so he's not going to defend her. And I understand that interpretation, but we kind of found out that there may have been a more boring explanation, and that was what more people told us. So that's sort of what we ended up thinking.
And obviously, if you read this brief, it's very, very forceful. His office is clearly not writing her off.
No. Yes. If there was any doubt, though, if people were saying, well, maybe there's a conflict of interest, but, isn't it saying something? Well, Rokita's now saying something, and it's very much defending Gull and saying that she should not be removed from the case and that these attorneys should have been disqualified. And we'll go through the reasoning presented here.
Yeah, and I want to start out, there's a number of sections in here I've highlighted that I feel is worth reading and discussing. And the first one is, it's kind of important to know, in my mind, how different people see things. And so I think it's interesting to see, why does the Attorney General feel that Rosie and Baldwin were removed from the case? What does he feel were Judge Gull's reasons to do so? And I would like to read that list now. Improper comments to the public. After stating they would not talk about the case, Baldwin and Rosie issued a press release that was potentially violative of the ethics rules. Conflict of interest. Rosie filed a tort claim on Allen's behalf against the DOC. Protective order violation. Baldwin negligently released discovery to Brandon Woodhouse, who disseminated it to the public. Baldwin did not alert the court or the state to the release. Filing motions with inaccuracies and falsehoods. The pleadings regarding safekeeping Allen and the DOC contained proven false information. Protective order violation. Baldwin was the source of more leaked discovery, which spawned a criminal investigation and may have resulted in a suicide. I think that last sentence in particular is pretty brutal.
That is very brutal, yes. So we're seeing this outside perspective that's siding with Judge Gull and explaining what they feel are the various reasons that these attorneys were removed. So that's the firing, that's the opening shot, I suppose. Yes,
basically, you've lied to the court. You didn't keep your word.
Can we just go into that? Because, I mean, why is lying, like, why is there such a big deal about that? I mean, I know, but for people who are saying, well, what's the problem with lying to the court if you're an attorney?
If you're an attorney and you're an officer of the court, your word is supposed to mean something, for one thing. And also, let's say you file something with false information and that comes out and the judge is aware of it. Perhaps the next time you file something, it's accurate information. Perhaps the judge is going to discount it because of what you've done.
Thus undermining your defense of your client because boy who cried wolf syndrome. Another question around this is, to me, in this situation, to be fair to the old defense team, there's stuff that I feel was stretched potentially, but I don't know if it's like an outright lie or somebody made a mistake. How do they, I mean, I'd be more curious to learn more about on the prosecution side of this whole thing, like what exactly they are saying. This is an outright lie, like this specific thing.
There's a lot of debate about that, including in these filings that we're going to be going through. Perhaps at some point it might be worth the time to sit down. Let's take a copy of this motion to transport order and go through it point by point alongside what was subsequently revealed at the June 15th hearing, which covered those allegations.
We were at that hearing, and there were some things that I felt that Nick McClelland, the prosecutor in this case, was able to pretty solidly push back against or even outright debunk. But again, calling it an outright lie when we know that sometimes defense attorneys do push the envelope as far as these things. Maybe they're stringing things together carelessly. Maybe they're stretching the truth. But to say like, I would want a list of lies, I suppose, because otherwise I feel like there's some gray area there.
That's certainly fair. Maybe let's go through it point by point at some point. Another example of potentially lying to the court would be the Judge Gull says you guys told me you don't want to try this in the press, and then the next thing I know, you're issuing a pretty detailed press release.
Yeah, that's.
And another instance of potential lying to the court would be they said they were withdrawing from the case.
Well, yeah, that to me is pretty. That I'm shocked that they did that because that seems so clear cut, and now they've kind of retconned that as like a strategy, but the strategy was to lie and say we're going to do this, and now they claim we had no intention of that. So it's not like we're going to do this, we changed our minds, we're going to circle back.
Yeah, so that's a question I have, which do we want to set a precedent where we're basically rewarding a lawyer for lying, for creating a situation where if a judge puts you in a tight spot, you can lie and say you're going to withdraw when you're not. And then a couple of days later, say, oh, guess what? I'm taking it back. And I'm not sure that's good for public policy. I'm not sure that's good for people being able to trust the things lawyers say.
Yes.
So that's a concern of mine.
Yeah, you don't want the lawyers to look bad in all this. Well, I mean, it's a fair thing. You don't want people to just be able to pull out the tell a lie Uno card and prevail, because that sort of breaks down the fundamental trust within the system. We've talked about a lot of situations where prosecutors and defense attorneys have treated each other collegially and they're part of the same system. So even though they're opponents, there should be a level of trust there nonetheless, if things are working correctly. But yeah, unfortunately, if either side is breaching that trust, then the system's, it becomes lopsided. It becomes a problem.
Then we get more into some of the arguments that the Attorney General's office makes. And the first group of arguments is more procedural. And I know a lot of people don't enjoy procedural arguments. I think we've all been in a situation where you're trying to play a board game or something, and some kid comes in and says, well, you've got to do it by the rules. You're not doing it exactly right. And people find that frustrating.
That kid's name, Kevin Greenlee.
But the fact of the matter is the legal system is based on rules. And there's a reason for that. And the rules are there to be followed. And so the first set of arguments is you didn't follow the rules. This writ of mandamus, that's an extraordinary step to take. And you can't just wake up in the morning and say, I'm going to file a writ of mandamus. You have to first do certain things with the trial court. You have to go through certain procedures, and the writ has to only be filed if certain conditions are met. And the argument here is those conditions have not been met. They say, for instance, that original actions, this is an original action, and they cannot be used as a substitute for appeals.
So go to the appeals court first, then go to the Supreme Court. Is that essentially you need to hit that level first before you bump up to the biggest level of all, which is in the state, the Indiana Supreme Court?
Yes.
Okay.
So basically, you're not following the rules.
Why do we think they didn't do that?
I think that's an excellent question. I don't know.
I wonder if there was a strategic reason or if they thought that the Indiana Supreme Court would just be the flashiest thing. I don't know. But yeah, you would expect this to go through an appeals court first. But again, maybe there's some strategic thing that's eluding us.
I'm going to read another quick excerpt here. Disqualification of counsel can be required or can be at the discretion of the trial court. The extraordinary remedy of a writ is not available where the matter is within the discretion of the trial court. An action for mandate cannot be employed to adjudicate and establish a right or to define and impose a duty. Here at the Murder Sheet, we work on the podcast and our investigative reporting full time. That means we sometimes don't have time to meticulously plan and cook delicious and nutritious meals. So, in this new year, we are eternally grateful to our sponsor, Factor.
Now's a great time to try out ready-to-eat meal delivery service, Factor. Remember, when you support our great sponsors like Factor, you're supporting us and our ability to keep doing this work. So please consider visiting factormeals.com/msheet50 and use code msheet50 to get 50% off.
Factor allows you to pop your ready-made meal into the microwave. In 2 minutes flat, you'll have a hot and ready dish with minimal cleanup afterward. It's just that simple.
Also, this food is awesome. I recently dug their black bean and rice enchilada bowl with roasted zucchini, corn, and salsa verde. It tasted so fresh and flavorful.
I love that we get to skip meal prep, the grocery stores, expensive to-go orders, and elaborate cleanup. Plus, there's plenty of options for extra picky eaters like me.
We've really been thrilled with Factor, and we feel you will be too if you're striving to eat healthy and save time in 2024. It's really helped me meet my nutritional goals for the new year.
Head to factormeals.com/msheet50 and use code msheet50 to get 50% off. That's code msheet50 at factormeals.com/msheet50 to get 50% off. So what they're saying there is these writs, not only do you have to jump through certain procedural hoops and do things in a certain order, they're saying that writs can only be issued in these cases if the court has a definite duty to act, which it is not acting upon. And they're saying whether or not trial attorneys are removed happens at the discretion of a judge. And what falls within a judge's discretion cannot be mandated by a writ. Does that make sense?
I think so. I know that when we spoke with Shay Hughes, aka Hoosier Public Defender, he's definitely in favor of certainly the first writ, and I believe certainly elements of the second. But he told us that writs of mandamus are not looked favorably upon by courts, by higher courts, because they're almost seen as like the absolute most extreme last measure that we should take. So reserved for an extreme situation. So that would indicate that what Rokita is saying here, what, the Attorney General's staff is saying here is that, they didn't follow the rules and do this properly. And now they're pulling the safety lever, even though there's not really a reason to. Is that it? Is that my dumb person summary?
Yeah, that's good.
I'm not a lawyer, so I don't know. Well, it's interesting. So this is a lot of procedural stuff. It's not really getting at the heart of the matter.
So when we get more into the heart of the matter, because of course they also say, well, even if all this procedural stuff was followed, there still isn't a case here for a writ. We know that the argument on the other side is that Richard Allen has a Sixth Amendment right to have Baldwin and Rosie represent him, basically. And in this brief, they argued that the right to choose counsel or to continue representation of your existing counsel is not absolute. And I'm going to read another quick segment here. The right to choose counsel is not absolute. While the right to select and be represented by one's preferred attorney is comprehended by the Sixth Amendment, The essential aim of the amendment is to guarantee an effective advocate for each criminal defendant, rather than to ensure that a defendant will inexorably be represented by the lawyer whom he prefers. So that means that I have a right to an attorney. It doesn't mean that I get whatever attorney I want. I have a right to an effective attorney. And if the court determines that the attorney I've selected is not effective, then the court has the right to change counsel.
That's what they're arguing. And my understanding, and correct me if I'm wrong, Kevin, but this can differ somewhat based on private counsel versus public counsel. If you have private counsel, you're paying for the attorney, or they're deciding to represent you pro bono, then it's harder to remove said attorney because you're paying for it.
Yes.
When the Indiana tax-paying public is paying for it, it becomes much less safeguarded that you can have this specific attorney.
Yes.
Okay.
That is true.
Discrepancy based on income, that makes me uncomfortable, to be honest, but that is how it's seemingly enshrined here.
This is probably a ridiculous example, but let's say I have cancer, and
oh my gosh, this is getting dark.
And I have a doctor who believes the way to treat cancer is if I pay him $10,000 and he'll give me a certain type of flower petal to chew on. I cannot expect my insurance company to cover that, because the insurance company would look at that and say, well, Kevin wants this doctor. He has a right to be treated, but we don't feel that this would be effective treatment of the underlying condition.
Right.
So they might be inclined to deny that claim. Now, if on the other hand, I was rolling in money and decided, well, I want to treat my cancer by paying this man $10,000 to chew on flower petals, yeah, sure, I'll do that.
Yeah, you can. No one's going to.
Not even you would stop me.
Well, that's what you think. That makes sense. You have more freedom in that situation.
I'm going to read a little bit from the next section here. Counsel's conduct or personal circumstance may justify removal. Gross incompetence or physical incapacity of counsel that cannot be cured by a citation for contempt may justify the court's removal of an attorney even over the defendant's objection. They even cite a case there. So they're making the point that what happened with her removing these attorneys is not unprecedented. If you find that attorneys are grossly negligent or grossly incompetent, the judge in previous cases has indeed removed attorneys.
Okay. So they're citing, I mean, I will say they're citing a lot of cases in this, though we have not reviewed all these citations. So as with anything under the law, I imagine there's probably different interpretations of some of this, but certainly a lot of cases crammed into this document.
Certainly more cases than we have seen cited in a lot of documents in this case.
Yeah, I would say so.
Though varied interests may necessitate overriding a defendant's preference, disqualification is an extreme remedy that should only be used when a court deems it reasonably necessary to ensure the integrity of the fact-finding process, the fairness or appearance of a fairness of trial, the orderly or efficient administration of justice, or public trust or confidence in the criminal justice system. And they cite the Rainey case there. And the implicit argument there would be that what happened in this case rises to that allowing Baldwin and Rosie to continue on the case would disrupt the orderly or efficient administration of justice.
And I'm sure the appellate team for the defense, or the old defense rather, would argue that, you know, this didn't rise to that level of extreme situation.
I'm going to read a longer excerpt now, One thing we've heard discussed a lot in this case is that there wasn't a proper record, that there wasn't, in short, a public hearing at which Rosie and Baldwin were disqualified or removed from the case. So this happened behind closed doors. Let's hear the Attorney General's office's take on that. The lack of record prevents review of counsel's disqualification. Defense counsel's withdrawal truncated the proceedings, and the present record prohibits complete review of whether the trial court's concerns justify substitution of counsel. In chambers, prior to the October 19th hearing, the court listed reasons it felt counsel should be disqualified that it intended to address in the hearing. The prosecutor was prepared to present evidence from the leak investigation. But this hearing did not occur because defense counsel withdrew rather than challenge the factual allegations at that time. At the October 31st hearing where Baldwin and Rosie attempted to appear for Allen and have their own counsel, no additional evidence was offered or arguments made to rebut the court's allegations. So we've been hearing that it's a huge issue that there wasn't a proper record made. But they're saying that the reason, in their view, there wasn't a proper record is because Baldwin and Rosie chose to have this happen in private, that they had an opportunity for some of these things to be addressed publicly and chose not to take it, chose not to put these things on the record.
Right. And I suppose the transcript of the October 19th in chambers meeting speaks to some of these issues. I think we found out that Rosie had asked for the in-chambers meeting. Is that correct? And so what Rokita's saying is, it's not Judge Gull's fault that you basically quit in the chambers rather than going out and getting a shellacking on TV, I suppose.
I guess the argument would be the old joke I've referred to before is someone kills their parents and then asks for mercy because they're an orphan.
Right. You created this situation. No one should feel bad for you. Okay. So, yeah.
Then they go through some of the things that were discussed at that closed door meeting, such as the court had concerns about counsel's candor. Baldwin didn't even tell the court about a defense outline of discovery information leaking until months after it happened.
I still want to know what happened with that. I know we had heard of the Woodhouse leak a long time, I think, before it was being, referenced in this setting. But it was surprising to me in the transcript that Baldwin indicated that he hadn't even told Rosie about it. So I'd be very curious to know, when did those discussions happen with Rosie, with McClelland, with the judge? What's the timeline there?
Yeah, because it appears that Baldwin not only didn't tell the court about it, not only didn't tell McClelland about it, he didn't tell his own partner about it.
And what weirds me is, what weirds me out, I suppose, is that Baldwin is himself admitting that in that transcript. He's not saying, no, that's not what happened. I told everybody. So it's not like, if we were just hearing that from McClelland or even Judge Gull at this point, I might be like, well, I don't know. Maybe he went into a little bit more, maybe he did something, but I don't know. That whole thing just haunts me. I wish I knew what happened with that, because that's shocking.
It is shocking. There's a section that which basically reviews from their perspective the things that they feel the judge was concerned about that warranted the removal of the counsel. I don't know if we need to repeat those since we discussed those.
No, yeah, we discussed those earlier.
But there is a point here that I think is worth noting. The record is also inadequate for full consideration of Allen's preferences. The record contains expressions of Allen's desire to retain Baldwin and Rosie after being informed of the leak. But the record does not show what Allen knew or understood regarding the leak. The court's other concerns about counsel's competence, how these matters impacted his ability to obtain a fair trial, or the alternatives available to him. Taken as true, the existing assertions of Allen's preferences are insufficient to determine that he is making an informed decision. I think that's something we've discussed, that
Yes.
Allen's letter doesn't really make clear how much he really understands about the extent of the leak, or if he understands these other matters at all.
Yeah, that really concerns me because he references specifically, I understand that images of Discovery were leaked. And that's certainly a big part of that. So he's grappling with that issue. But what he's not addressing in the letter, and what it's not clear if he knows about, is the defense strategy, the fact that was leaking and that Westerman and Baldwin were seemingly talking about it and it was getting out through the leak. That's not discussed, and I don't understand why that wouldn't be referenced, and it makes me, that would be a concern that he's not aware of the full picture, but he's still making these assertions or decisions. You know, it's possible that he is aware and he just sort of did shorthand to say, well, I know about the leak of the images, but yeah, it's concerning. So like, if I'm kind of trying to express my thoughts on that in the form of a very stupid metaphor or analogy or whatever you want to call it, it almost strikes me as like if a teenager has a massive rager at his house while his parents are away, and then he calls, you know, they get busted by the cops and he calls to tell them, hey, I had this party, our house is trashed. But he fails to mention that as a result of that party, the house caught on fire and was severely damaged structurally. So it's like you're telling half of it, but maybe not another part of it that's also important, if not more important. So yeah, that concerns me.
So the final thing the defense team was asking for was, we want the Supreme Court to grant Richard Allen's request for a speedy trial. There's a mechanism in Indiana where a defendant basically can file something and a trial has to happen within 70 days. I'm simplifying it a bit, but that's basically it. And they're saying, we want you to grant this. The Attorney General's office is saying, well, you need to follow the mechanism. And you're asking the Supreme Court to grant a trial court motion, and that motion hasn't even been presented to the trial court.
Okay, so they're saying that you need to start several rungs down the ladder before you can jump to the top of the ladder there.
Yes. You need Richard Allen to actually turn in this filing. You know, they mentioned that Richard Allen had signed a request for a speedy trial back in August, but they hadn't filed it. So they're asking the Supreme Court to basically act on this unfiled motion. And that's really not the way things work.
Why would the people who wrote the second writ of mandamus even mention that? To create a sense of urgency strategically?
Maybe to create a sense of urgency strategically, or I think there's certainly some perhaps posturing, like we're ready to go right now.
Yeah. Not very likely, honestly. A lot of this just seems like posturing at the end of the day. I mean, like, just a lot of what's been going on in this whole sideshow. It's just, I don't know. I don't really understand some of it because it's like, that's not how anything works. So why file it that way?
There is one more thing that I neglected to mention. This, of course, is that there was a request for Judge Gull to be removed from the case. And again, this is something they address procedurally and then in terms of the merits. And procedurally, they say, well, this request was made by Brad Rosie at a time when Brad Rosie was no longer representing Richard Allen. And they note that the defense cites no authority that a trial court must entertain a motion by an attorney who is not the party's current attorney.
It's like you couldn't sweep in and say, I want a speedy trial for Richard Allen.
Yes.
Because you don't represent him.
You don't have standing.
No. Well,
I can't like go into the Murdoch case and say, I want Murdoch to plead guilty and here's my motion. You need to actually represent the client. And then in terms of the merits, you need to, if you want a judge to be removed, you have to provide some sort of reason. You have to show that they are biased.
Okay. So, like, what would that look like? The judge sends them, like, an email saying, here's why I think you guys suck. I mean, honestly, what would that look like?
Well, I'm going to quote you something from here.
All right.
Allen only points to the judge's rulings in this case to argue the judge is biased. This is not sufficient. The mere assertion that certain adverse rulings by a judge constitute bias and prejudice does not establish the requisite showing of personal bias or prejudice. So, in other words, just because a judge rules against you, that's not enough to stand up and say, this judge is biased. Because every ruling a judge makes is going to be for someone or against someone. And, and just because some of them happen to go against you, that in and of itself is not enough. Because
while it could be biased, it could also be that your motions are bad and the judge doesn't agree with you, right?
Yeah, it was just it's just a matter of judgments and stuff going against you and rulings going against you. There's an appeal process. You don't have to immediately say, oh, you ruled against me here? Well, you should be off the case.
Why would they do this way then? It just, I mean, if the goal, I look at things strategically. I'm not really looking at this point like it's true or false. It's just more of like from a strategic standpoint of maximizing your chances of success in this situation. It seems like there have been some errors made here, or maybe not errors, but it seems like there's some things that are suboptimal for this appellate team, especially in this writ of mandamus, in this specific one. And it just makes me question, why do things that way? Because it doesn't really maximize your chance for success.
It seems like a lot of the times throughout the history of this case, it seems like there have been many occasions where the attorneys associated with the defense have, in terms of strategy, not really thought more than one step ahead.
Yeah, it really seems like a lot of this is incredibly improvisational and just okay, here's the next thing, and not thinking like what would make sense for, a few weeks from now, a few months from now, for attaining the ultimate goal that we have here. But it's just surprising. It's just surprising because you want to read strategy into things, and sometimes I just don't think it exists.
Well, let's move on to Judge Gull's brief that was also filed this afternoon. And of course, when I say Judge Gull's brief, she didn't actually write this brief. Her attorney's team did.
Matthew Gutwein.
And so that's important to note. But obviously, she was their client, so this represents Judge Gull's beliefs and
they're
thoughts.
Speaking on behalf of her.
Yeah, sometimes it's kind of funny sometimes when you read legal motions. They always refer to the motions as if they were filed by the defendant. So you hear like, well, Richard Allen maintained this ruling in the court, blah, blah, blah. And obviously Richard Allen is not sitting there with his tweed coat maintaining this or that. It's Richard Allen's attorneys. It's
right.
just
but they're representing him. They're there for him. So they have to, use him as all these people are using, it almost sounds like people are using each other as ventriloquy dummies, but it's really more of reflecting that they're acting on his interests in this situation.
So some of this is going to be similar to what we've heard and discussed in the Attorney General's brief. But I'd like to start at a similar place where we discuss a little bit about how things seem to Judge Gull and how that things seem to her team. The record supports that attorneys Baldwin and Rosie were providing ineffective assistance of counsel. Relators counsel 1. Failed on multiple occasions to take reasonable steps to safeguard confidential case materials. 2. Made extrajudicial statements that had a material likelihood of prejudicing the case. 3. Provided false information to the court. Before removing Relators counsel, respondent afforded relator with notice and opportunity to be heard through written submissions as well as argument in chambers and on the record in open court. So again, they're saying there was good reason for these counsels to be removed. And they're also adding, by the way, you had notice.
Right. I mean, I can understand the argument that, like, clear notice doesn't necessarily seem to have been given well ahead of time. Although there were obviously discussions of them being disqualified. The formality of this seems in question. But essentially what I'm hearing her say is if they wanted something or if they wanted to fight, they had an opportunity to. They could have had the hearing. She would have disqualified them, and then they could have appealed that.
And they didn't, for whatever reason.
No,
they didn't.
They did not. They instead told her that they were both withdrawing, which is not what happened. Or then they went back and said, no, we were just lying. Let us back in.
The brief starts in a similar place as the Attorney General's brief begins, by talking about procedural matters and precedent. I'd like to read a quick thing here. This court has never issued a writ to reinstate counsel where, as here, the trial court removed counsel based on the court's reasonable findings that counsel had engaged in multiple acts of gross negligence, compromising the accused's constitutional right to competent assistance of counsel. That's an interesting sentence because it really packs in a lot of information because, of course, an argument is that Richard Allen's constitutional rights were being violated. But even in this procedural section, Judge Gull is saying that, well, actually his right to an effective counsel was violated by the way Baldwin and Rosie were conducting the defense.
So they already did that, and to keep them on would have been to violate his rights because they'd proven themselves to be incompetent, ineffective counsel by nature of this leak and other issues that were going on prior to this.
Exactly. And there's another line in this brief from Judge Gull that really jumped out at me. And I think it might jump out to our audience and to you as well.
I know where this is going.
Relator relies for the most part on cases from outside Indiana.
Oh, man. Yeah.
We know that Judge Gull throughout this process, throughout the entire time the Allen case was before her, she frequently complained about Rosie and Baldwin citing
Illinois,
out of state
North
cases.
Carolina.
But they kept doing it.
That's what I'm saying, the improvisational, because it would be like, here, when you do something and the audience boos, maybe you do something different, but their audience, their true audience, not the internet people, not us, not the media, their true audience was an audience of one, Judge Gull.
Yes.
And she'd say stuff like that. Why are you citing all this out of state law? Not federal law, but just out of state stuff. And they'd be all like, ugh, and then they'd keep doing it. And it was like, they're not listening. That's crazy to me. That always fascinated me because there was something like, oh, well, why? Is there just nothing in Indiana that backs this up? In which case, maybe just don't do it.
It's bizarre. The focus should have been on Judge Gull.
Well, yeah, but they had the razzmatazz to bring to all the YouTubers.
It's like on a personal note, for whatever reason, I really don't like chocolate, and so it'd be Anya wants to buy me some Valentine's Day gifts, and she buys me lots of candy chocolates, and meanwhile she's telling people, "Oh, look, I'm buying Kevin chocolates. Doesn't this mean I'm great?" But she's forgetting
that you asked for no chocolates. No, it's even weirder than that because it's like, it's not effective lawyering. It's not just that Judge Gull is being mean. I think it's fair to say in these situations that the thing that's going to be most relevant is Indiana law because we, in fact, are in Indiana. And so you would I would imagine, see filings citing state law or federal law.
yes.
Not, here's how they do it over in Cali.
And on point, this section concludes with relator identifies no case from this court or the United States Supreme Court that affords him a clear right to an extraordinary writ for the relief he seeks. So they're saying there's no federal case, there's no state case that supports what you're saying.
I mean, this is a minor thing within the appellate process, within this whole mess. But yeah, that haunts me because I just don't, that goes to the lack of strategy. That goes to the kind of like, let's just do whatever comes to mind. And that concerned me at the time. And that concern has maybe grown into some level of bemusement, but it's not really left me because it just seemed always like you want to be doing things to maximize your chances of success for your client. And when you're doing stuff like that, it's just sort of like own goals.
Yeah,
you know?
It's odd.
It's just, I don't know. I don't understand it.
Here's how Judge Gull summarizes matters at the end of this particular section. Relator asked this court to use an original action to rule for the first time in Indiana that the Sixth Amendment prohibits a trial court from removing counsel whom the trial court has reasonably found to have been grossly negligent.
Okay.
So they're saying there's no precedent for this, and really, do you want there to be a precedent for the Supreme Court to be asked to step in? If a trial court judge says, oh, these attorneys are negligent, does the Supreme Court of Indiana want a lot of people sending them cases to review determinations like that?
I mean, just to be devil's advocate here, do we? Is there a benefit to that?
Is this really a big problem? Number one. And number two, why? Well, I'll be blunt. Typically, Supreme Courts don't do things to increase their own caseload.
Mm-hmm. Yeah.
They're looking for things like, or there's a lot of controversy here, let's settle it. Let's settle this or that.
Put out the fires.
They're not saying, hey, everybody, send us more cases.
Yeah. Okay. Well, yeah, which is, again, is surprising that they went to the Supreme Court instead of an appeals court, right? Because I would imagine an appeals court, you might have had an easier argument of like, hey, they messed this up. Okay, send it back and do it over, guys. All right. That makes sense. That's a good strategy. Unless there's something I'm missing here strategically or that wouldn't have worked out, but that's a good strategy. But, Supreme Court sounds fancier.
Next, they move on to whether or not Richard Allen's Sixth Amendment rights to counsel were violated. I'm going to read some excerpts here. I'll be jumping around just a little bit. A criminal defendant's Sixth Amendment right to effective assistance of counsel outweighs his limited right to select counsel. As this court has explained, the right to counsel in a criminal proceeding does not mean the defendant has an absolute right to be represented by counsel of his choosing. The appointment of pauper counsel is within the discretion of the trial court and will be reviewed only for abuse of that discretion. The qualified right to choose one's own counsel must be placed against the backdrop of judicial discretion. Traditionally, courts enjoy broad discretion to determine who shall practice before them and to monitor the conduct of those who do. The Sixth Amendment right to choice of counsel merely informs judicial discretion. It does not displace it. The trial court is granted considerable discretion to remove counsel so that the trial court has the tools to preserve an accused's Sixth Amendment right to competent and effective assistance of counsel. So again, this is a similar point as what was in the other brief, that what the Sixth Amendment really guarantees is competent, effective counsel, and that is more important than counsel of your choice.
So the defense in this side is arguing that it guarantees him representation of his choice. His rights were violated. His Sixth Amendment rights were violated because they were removed. Those are the attorneys he said he wants. And so it's a violation. And what the prosecution is saying is, if the attorneys that he wants are incompetent, then that violates his rights. And that's a more severe issue. So they need to be replaced with competent counsel, and then things can move
to
forward.
Safeguard his rights.
Right.
And the argument they are making is that it is up to the trial court judge to safeguard that, because the trial court judge is the one in the trenches. She's the one watching and observing these things.
Okay.
Does that make sense?
Yeah, I think so. I think I understand both arguments.
There's another nuance they add a little bit further down. Moreover, the trial court need not delay taking remedial action until counsel's incompetent representation causes the entire trial proceedings to be constitutionally defective. So that's what they're saying there, is that the judge doesn't, if the judge sees a problem and sees that it's growing and getting worse, she doesn't have to wait for it to become a complete disaster before taking action. If she believes counsel is acting negligently, and then that negligence is likely to continue, she doesn't have to wait for them to make a huge error. She can just go ahead and remove them.
So if like a state trooper sees someone driving really erratically, he doesn't have to wait until they crash into a brick wall to pull them over.
Yes.
Okay.
Or if someone is burning trash right by a pile of wood that's right by a house, you don't have to wait for the wood to actually catch fire. You don't actually have to wait for the house to catch fire. You can say, maybe that's not safe.
Don't do it. Okay. So that's interesting. Where is the line? that was something that I was thinking of. Like, if you see someone, you're like, okay, I don't really love that they're doing this. Where's the line where they're like, this is becoming constitutionally unsound? But yeah, I guess that is up to the judge's discretion.
I guess that's up to the judge's discretion. And the argument would be, maybe you agree with the judge on this, maybe you don't, but is the determination reasonable? And they repeatedly list the reasons why she felt they were negligent and warranted removal. And so the question is this reason enough? Could a reasonable person look at this and say this is enough that they have to go? And they're arguing in the brief that yes.
Okay. But they are leaving room here. It's not like all judges necessarily have to do the same thing. It's more of that there's a range of reasonability that can be applied here.
If a judge says, oh, this particular attorney is wearing a purple tie and I don't like purple, this attorney's off the case. No reasonable person would.
Yeah, because purple's the best color.
That's right. And then again, we have a listing of what happened, the reasons why, making the point that even Rosie understood that Mitch Westerman would regularly visit Baldwin's office and that Baldwin would share information with him. So it's just trying to go through this and, Baldwin emailing work product to Brandon Woodhouse, the extrajudicial statements.
And the whole thing with the Westerman thing kind of ties in Rosie too, because I think there's a fair argument to make that that's Baldwin's problem. I think what the judge is saying here is that, well, Rosie was in the know about this and seemingly didn't stop it.
And also they highlight that in the judge's mind, Baldwin and Rosie actually provided false information to the court in that motion to transport Richard Allen. And it's important to note that motion was written by Brad Rosie.
Yes, it was. And
also Rosie was the one that filed a notice of a tort claim, which raises potentially conflict of interest issues.
The central premise of that safekeeping filing was that Allen was being treated significantly worse than other inmates within Westville. Is that right?
Yes.
And the hearing sort of revealed that was, at the very least, in question.
This brief actually quotes a line from Judge Gull's July 19th order, in which he indicates that the evidence presented at the hearing did not support what was put in the motion, which is a very nice and polite way of saying you guys lied.
Right. Yeah, that's interesting.
And so as a result of all this, it indicates Gull became gravely concerned with Richard Allen's right to have competent, non-negligent representation.
Okay.
I'm going to read, again, a bit of a summary. The professional norms in Indiana are violated when counsel fails to safeguard confidential case materials, provides false information to the court, and makes extrajudicial statements that are likely to prejudice the case. So again, we just keep on having it hammered. This is what they did, and this is not what's done in Indiana. It's not professional. It was negligent. It was incompetent, if you will.
Okay.
Then there is a lengthy section saying they said they didn't have notice, but guess what? I believe they did have notice. And I'm going to read from that. On October 11th, 2023, Relator wrote, "The record confirmed that respondent provided Relator with ample notice that the trial court was considering disqualifying Baldwin and Rosie before October 19th, 2023. On October 11th, 2023, Relator wrote a letter to respondent requesting that Baldwin and Rosie continue to represent him and acknowledging that the prosecutor was seeking Baldwin and Rosie's disqualifications. On October 12th, 2023, Rosie wrote a letter to respondent arguing why he and Baldwin should not be disqualified. On the morning of October 19th, 2023, an attorney representing Baldwin filed a memorandum regarding possible disqualification and sanctions. Relator had adequate notice and opportunity to argue against respondent's disqualification of Baldwin and Rosie. Baldwin and Rosie also had the opportunity to proceed with the scheduled court hearing on October 19th, 2023, but chose to withdraw instead. At the October 31st, 2023 hearing, Baldwin and Rosie further argued against their disqualification after filing new appearances, and the trial court afforded them an opportunity to be heard on the record, including via Baldwin's counsel. The trial court afforded Relator adequate process.
I suppose ultimately the Indiana Supreme Court will determine whether that's enough process. I know you and I have raised concerns about that.
Yes.
And I do feel them. I think it seems unofficial to have things like, oh, well, they knew about it, because them knowing about it means that it's not an ambush, but them knowing about it doesn't mean that there's been a proper process followed. I don't know what the process is, so I'm not saying that I'm definitely right here. I'm just saying that it makes me uncomfortable, and I suppose that will be ameliorated by whatever the Indiana Supreme Court feels is prudent. But yeah.
At the very least, they clearly knew that disqualification was on the table.
Oh, I mean, yeah, that's not up for debate anymore. But the question is, was there a process that was you would think that something that's as extreme as attorneys being disqualified would have a very sacrosanct process in place of, excommunication, essentially. But that doesn't seem to be what happened here. Maybe that doesn't matter. What they're arguing is it was enough. So I suppose we'll see.
Then Gull gets to the request for her to be disqualified. She makes the argument we heard before that, these guys no longer represent Alan. So why should we pay attention to their motion to have me disqualified? If his current counsel want to make such a motion, maybe we can address that then.
Right. Does that take us through the end?
The only thing left is the speedy trial date, but again.
Yeah, that just...
Yeah, that's basically it.
Yeah.
So what's your big takeaways, if any?
It seems like a very, once again, citation-rich filing. Some pushback, I suppose, would be, I don't know, I guess I'm not completely convinced by the due process element of this. That being said, a lot of the points, again, point to a lack of strategy on the part of the appellate team here, in my view. Seems like, again, there's things where it's pointed out and you're like, oh yeah, that is kind of a gaping hole in what they're saying. Eesh. When you look at the house on the first time, or on Zillow, it looks great. And then you show up and, there's mice activity and termites and stuff. And you're like, okay. And that sort of feels like maybe that's why I view this second mandamus as so much weaker than the first. First really seems to stick to a lot of specifics and, principled arguments. And this mandamus has more of the effect of let's throw all our big asks in a bucket and try to splat it at the wall and see if it sticks.
Yeah, I would agree with that. At this point, I'm hoping that the Supreme Court will rule relatively quickly so this process can get moving. And I hope that people are able to accept it, whatever the court rules. We can guess what they will rule, but obviously we don't know. Already, I'm seeing online people who have a more conspiratorial frame of mind are saying, oh, look, the Attorney General doesn't support the defense, therefore the Attorney General is corrupt. And there's a lot of people who seem to have the belief that if particular things don't get ruled in a particular way, that it indicates corruption. And that's not the case. Speaking here with you today, I have no foreknowledge. You have no foreknowledge of how the Supreme Court will rule. We can make educated guesses, but they're just educated guesses. But I can say that the Supreme Court is not corrupt, and you and I will accept their ruling, and I hope other people will as well. Even if we disagree with a particular ruling, that doesn't mean that the whole institution or the people in it are corrupt.
Given the inflamed and ridiculous rhetoric that has become so prevalent in this case, thanks to a small number of bad actors, I think that's very much worth stating, as it is worth stating that in this matter, in these kind of like highly specific legal filings and whatnot, it is very much possible to disagree with statements or outcomes and think it's wrong, and not to be accusing those who you feel are incorrect of being like part of an Odinist cult that's destroying Indiana. I think there's ways to have these conversations, and when people turn to conspiracy theories to explain things that they don't like, they're actually damaging their own side to an extent, because it makes it impossible to have like informed debates with people, because they just jump to, well, everything's a conspiracy. And it's like, we can actually have a lot more interesting conversations if we're looking at this from the lens of like, perhaps I disagree with this, here's why, legally speaking. And we'll continue to cover both sides of this and try to keep it within the realm of reality rather than the scary Odinist reality that all these people live in, where everybody who is disagreeing with them is a crypto Odinist.
Thank you so much for listening. Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.